question is, since we have this bifurcated flip tax, X% of profit, Y% of gross, the question is, in that sale for profit by the child today, what's the basis for computing?
Reconstitution. And we get to,
If that's what we wanna do, then fine.
That's
So,
what I just.
and here's the thing, we exercised this last year, we actually exercised that right.
Okay, since you won't call me, I'm just gonna speak, so.
Well, go ahead, Ian.
Okay, we had to get counsel, we had to pay counsel, they charge $400 an hour and all this stuff. I think we should clarify this, so instead of this coming up in future years, some shareholder says, this is the wrong basis, we spent
We
another
have the letter.
$800 on lawyers.
Andy, we have the letter.
So a new board,
We
can make
passed
a
it.
decision. I think it should be in writing, it should be clarified in writing how we do this. But now I think I'm different. Lawyers seem to wanna say the minimum amount
Andy,
possible.
this is
As
not a
scientists,
lawyer
we
writing
wanna make
this.
things clear.
Wait, listen, this is not a lawyer writing this. This is the committee writing this.
I'm
Doug,
talking about the philosophy
But-
of whether you wanna say the absolute minimum or you wanna be as clear as possible.
no, the rules are simple. If you want to reconstitute a department, and it changes hands once to your family, changes hands again to the family, and that generation sells the apartment, the reconstituted price is the base.
And why don't we write that down?
It is, that's the way.
Let's put it in the bylaws. Why
It's-
not? Why not?
Could I
Go ahead, Doug. It is in the bylaws, we need
Why?
it.
It's a why.
That's why we need
it to be clear.
What he's saying is that the bylaws, if this is what we want to do, rather than the somewhat confusing terminology that now exists in section 61, we should simply say that in the.
We should adopt the
in this
language.
example, the basis for computing profit will be the.
I agree. So we should incorporate the language from the letter that the board voted on as the policy of how we deal with the
Yes.
passage of time.
You have it somewhere, right? Remember?
All right.
No, I don't know where you did that. No, it didn't.
Oh,
I would just like to be clear, and this is really just procedurally, I don't have a dog in this fight, that if you did that, that should not be perceived as a recommendation from the bylaws committee. Because I'm not sure that's where we came down on that. I don't think it's a
Well,
problem.
if you came down on a different side, you were working from a wrong premise. Because the bylaws do speak to this, and that's why we had the interpretation.
No, these are recommended changes, right?
No, but what I'm talking about is the transfer and the payment of the flip tax is in the bylaws. It wasn't specific enough, so we had to have the corporate attorney put it in the letter explaining all this, and then we voted the policy to be sure that this is the way we will do it, and there's no question.
And that's something that happened in this world, and this is something else that happened in this world, and they're not the same thing.
They are the same.
No.
they have to be.
We're having a little translation problem here. Brad is saying that he thought we were recommending something other than what we're saying.
That's correct.
That's all he's saying.
Yes, but that would be a change in policy.
That would be a change, there are a lot of changes, these are bylaw changes, that's what we're talking about here tonight.
But the bottom line is that the board does have the right, of course, to change anything they want in there and then present it to the shareholders.
That's exactly right, and all I'm saying is that it should be represented like that.
Okay, but I think what happened in the, Brad is right that we were trying to pull away from that, the interpretation that the board took on these second generation sales, but you see now what we didn't do was to clarify what the basis for
Precisely.
that
That
point of
last
sale
sale.
would be.
Sure.
If you're going to have a bifurcated flip tax, you've gotta have a way to compute the basis on each sale.
Which one is greater?
And we didn't really
Right.
define what that
That's
basis
my
was.
recollection too. You're right.
None of those are actually sales. Money is not,
Exactly.
money is not changing.
That's the
hands.
point.
Only in the last
No, but the
case.
last-
I know,
the
we're
last-
talking about
that's the issue.
when the son,
Right.
when the child sells the apartment, that's a sale.
And it should
They
be.
sell it for $500,000.
They can sell it for $1 million, and it should be the difference between the right to reconstitution and whatever they sell it for.
Right.
But
And that's
should be
exactly what Doug is saying, that we need to
And if-
define
and if it is
process.
not-
Here's what we're going to do. We're gonna send the committee.
One moment, can't I finish?
Yes.
And if it is not the difference between that price and what they sell it for, it is unfair to everybody else who has been in this co-op, who sold before they passed it down to 500 generations. So it's got to be that.
Here's what we're going to do, we're gonna inform you of what the policy, I just want you to know, we're gonna inform, I understand, but I want you, the committee to understand. Russell's gonna send you the information about this, what we passed, as the formal policy, so there is no ambiguity, okay? But I am telling you, we're taking out the note, it's not getting voted up here, okay? And I do not believe it has to go in the bylaws until the board decides it goes in the bylaws. All right, the note is gone. Kyla,
Yeah, I just wanna, you don't perhaps have your bylaws with you, but on page 57 of the 2007 bylaws,
What
all this
section,
is,
Ira, what section is that?
It'd be,
section 61C.
61C, yeah.
It's all spelled out, there's a chart here of those post-reconstitution,
Right.
immediately post-reconstitution prices.
These are the
So this
reconstitution
would not be a change,
that's why I'm taking it out.
this would not be a change, correct?
We don't need the note. The note is irrelevant. The board's policy has always been, and we have always executed that way, only because we were challenged by someone who had the benefit of receiving the apartment in a second generation move by the sole remaining parent. And then moved in that apartment, then put his wife on after he married, and then had children, and then decided to sell. And they were making an argument that said, I shouldn't pay for reconstitution to now. Well, that's not what the bylaws say. And that's what we collected. We collected from reconstitution to the day they sold it. Correct? And so there's no issue. So the only thing that's gotta go before the shareholders is SIGA. Okay? Good? All right. What else?
Okay, under 6, have a look, there's a comment here that we haven't discussed.
Okay?
Council recommends considering eliminating tenants in common as a means of ownership.
Instead of using the term tenants by the entirety, right?
Well, they're not the same, they're not the same thing.
All right. Somebody explain to everybody who doesn't know what the heck they're talking about in that comment.
Tyler, what number are we?
6. What does this mean?
Yeah, tenants were
Tenants entirety does not mean the same as,
Tenants by the entirety is like, tenants in common, but it's a term which is applied to married couples. By law,
which term applies to married couples?
tenancy by the entirety. Anytime, it works basically like tenants, it works like joint tenants. It's the equivalent of joint tenancy for, with rights of survivorship for a married couple. Anytime a married couple takes property in New York, it's deemed by law to be tenants by the entirety. It functions basically like joint tenants with right of survivorship, meaning one person dies, the other person automatically becomes the owner.
Instead of the mother-in-law getting
All
half
right,
of the.
so I am totally confused. Is the attorney, are you, based on the attorney's advice, using the word tenants by the entirety? Or have you just quoted that, meaning tenants in common? And if that's the case, we have to bring it to neutral, which would be joint survivorship.
Wait.
Because we cannot, I understand from our attorney, we are not permitted to say that married couples is a definition, or domestic partners is a definition. Those are not allowed. Two people can come to this co-op and apply for an apartment. They don't have to have any more relationship than they want to buy the apartment. Only one must pass the financial requirement. If one passes the financial requirement, we are obligated to approve them, as long as we believe the price is correct, to approve them, sell them the apartment, and both of them share in total responsibility once they buy it of all debts or anything else that are accrued. So how do we bring that generality of no formal relationship into number 6, which is what's supposed to be? There should be no tenants by the entirety. There should be no tenants in common. It really should be joint ownership is the only words we should be using of any two people owning the apartment. at the time of sale.
Okay, Larry, that's kind of what our lawyer was saying, except that you can't eliminate tenants by the entirety, because that's the term that applies to married couples. That's just a matter of law.
So-
What he's saying
Tenants
is
in common.
that if an unmarried couple buys an apartment together, we should be transferring to them as joint tenants, not
With
as
rights of
tenants.
right.
Right.
But they don't have to be an unmarried
No, but-
couple.
no,
They
but
could be
an
two
unmarried-
guys.
no, but
They could be two gals.
Two
They-
people, but they have to sign on as joint
Right.
tenants
Right.
with rights of survivorship.
Right.
What it means is that if that partnership
It's not what we're talking about.
if they don't get along anymore.
Right.
A cannot say, okay, I'm taking my half
They
and
can't.
selling it.
They can't.
They don't have that option.
That's right.
And they
So
gotta
what are
put
the
that
words,
money in.
so what is the change was make to make the language correct in the bylaws? What other words, should we use tenants by the entirety / joint survivorship? Is that what we need?
No, I think you can only use tenants,
prohibit
by the entirety for married couples, so you need that and JWTROS.
That's what I'm saying, /
Not tenants, well, no, you'd have one or the other, but we already have, I think we already have joint tenants. with
Yes,
rights
of course,
survivorship.
most of us are.
We have that, but we're just saying to add tenants by the entirety.
Okay, so,
The
And
lawyer was
eliminate-
suggesting eliminating tenants in
tenants
common.
Let's throw that one out.
Which one?
What the lawyer was saying.
what is the lawyer saying to,
Like what the lawyer is saying?
I'm so confused. What is the lawyer saying? To eliminate joint, this is what this comment is.
Tenants in common is not joint
That's the same
tenants with
thing.
rights of survivorship.
Quite different.
It's not the same
Not
thing.
thinking, but the lawyer also didn't understand the 50% versus 100%, and not owning less than 50% of the shares, right?
Mhm.
There's another comment that he has there.
He didn't get it.
To me, it's like if you have ownership, that's 50%, 50% ownership, wouldn't you need tenants in common? Wouldn't you need that phrase in there?
If what, say that again?
If we're permitting, say 50% ownership, if that's allowable,
Sure.
wouldn't we also then need tenants in common?
I don't think so, because I think that earlier provision we were talking about, the 50%, 100% provision, simply means that you can only have, you can have no more than two people in the stock, and each would have half.
Exactly.
1/2 of an undivided interest in the shares.
But if we're permitting that,
Yeah,
isn't that saying tenants in common is okay? Because that's not the same. If you have two people who are married or like joint tenants, in other words, with rights of survivorship, that's tenancy by the entirety. That's not 50%.
Isn't it 50%
It's,
well,
it's not 50%. It's you both own everything. And if
But-
one
but
of you
it's
that's
dies,
why they call
then
it
you
an
own it.
undivided 50% interest.
But,
Right, you see that coming.
here's why it's 50% interest, okay, on two people who are living in the apartment. If A throws B out because they can't get along, and B says, okay, I'm gone. A wants to bring someone new into the apartment. The new person, C, could own the other half if B would sell it with a flip tax.
Right.
Tax on 50%.
It's the fifth, it would be flip tax on 50%, but then
And I'm
there'd be a
saying-
new second person in the apartment
Right.
on the stock certificate, so it would be A and C on the stock certificate now, not A and B, and that's why it's 50%
Well, we're
each.
saying tenants in common is okay.
That's what I'm trying to understand, what is the language that's there now, and what is it we need to add to make it
What we're
right?
saying is, stock ownership, you can own 50% of the shares.
No
right?
problem.
Right? That means that we're a tenant in common.
I don't think that's
Well,
necessarily
no,
true.
yeah.
I don't think that's necessarily true. I think what the lawyer is recommending to us is that because of the scenario that Larry just described, if those two people, the original A and B, if they owned the apartment as tenants in common, then it's theoretically possible for B, who got booted out, I believe, in that story,
Yes.
to sell his interest in the apartment to the unfortunate C. So, those kind of scenarios are very unlikely for us, for obvious reasons. But that transfer, that theoretical transfer can only happen if shares are owned as tenants in common. If they're owned as joint tenants or tenants by the entirety, one of the people can't dispose of his or her interest independently of the other. That's why the lawyers recommend to do away with tenants in common as a form of ownership, so that even in theory, one party is not free to dispose of his or her interest independent of the other joint owners.
So if I'm understanding why the 6 is here, that's why 6 is here?
So he's
I'm
saying
still
that-
confused, because this is what I wanna understand. This is the thing I don't understand. Do we now have in the bylaws the words tenants in common?
Yes.
Yes.
Okay, so we want to remove the words
Yes.
tenants in common
That is-
and use the words tenants in the
By the
entirety.
entirety.
Is that right?
And joint tenants with right of
That's right.
survivorship.
So-
May I read for a second?
But it's short, but let's, oh, go ahead, that's
The
good.
very first sentence in the bylaws, the term joint stockholders, as used herein, shall be deemed to include stockholders who own shares of the corporation as tenants in common, there's that dirty word, as well as those who own shares as joint tenants with rights of survivorship.
Okay.
So if we were.
All right.
You lawyers can tell me, if we were to remove the words tenants in common and replace them with tenancy by the entirety, would we be accomplishing this goal?
Yeah, I think so.
Okay, so here's what's wrong with this number 6, if it's gonna go out to the shareholders.
Okay.
It should say, remove the words tenants in common, replace with tenants by the entirety.
Agreed.
That's what it should say.
100%.
Can the committee make that happen? And does the board understand that that's a change that we're making
Yeah,
as
that's a
part of the
change.
vote now?
Yes.
Okay, so,
So, a married couple may still, joint tenants, whatever, that is still there.
right, okay,
The
now,
mother-in-law cannot move.
By the way, just some information, but when we do transfers now to unmarried couples, are we not doing it in joint tenants with right of survivorship? Or
Yeah.
do we do that?
yeah, it's stamped, the stock certificate says, it's automatically stamped. All right, so now we've just finished with number 6, we know what we're doing, it's going to say something entirely different, the language is going to read what? Who wants to put the language down, you're the committee.
For number 6,
Michael's working on it.
In section,
And replace.
Eliminate.
Tenants by the.
Eliminate the words, quote, tenants in common, end quote, and replace with tenants by entirety. By the entirety, and that's in quotes, and cross out every other thing that's there, okay? All right, now, what else? We're almost ready for a vote, we're close.
yeah, I wanna raise a question about 7.
All righty, Isla.
And this is a question to my fellow committee members, I think. Are we really sure that, we need to add a provision that states this, that section 60 doesn't do it?
It always seemed like a tautology to me.
I don't.
What did you
I
say?
think we should
A
check
what?
this again.
Tautology.
Unnecessary.
Close in the circle, chases its tail.
Okay, don't use big words.
Sorry, it's only 7 letters.
What's the provision that you're referring to in 60?
In 7, it seemed that.
No, you said in section 60, right? Well, I said
I
what?
think section 60 pretty well covers it. I'm not
Where,
quite sure
where
what
in
we're
section
after.
60 are you referring to?
All of it.
That's a lot of pages.
Yes.
Okay. Most of which are getting.
I have never understood that anything else could happen. I thought that no sale could take effect unless all the flip tax is paid, and we guarantee that at the table with the attorney. When we go to a closing, but I just want you to know what happens.
Well, Larry, obviously, we're not making the transfers without this being complied with. The point is that right now, the bylaws don't explicitly say this, that's all. I believe we discussed discussed this when Bert was at the meeting, right?
And Bert agreed?
That this was not in the bylaws, it was supposed to look in 50/50.
It's not explicit, it says that, all stockholders shall pay to Morningside a portion of the proceeds as, the corporation's participation. So that has to happen. But, there are a series of steps, including the approval, the right of the board to approve an incoming tenant, which need to be complied with. And then, of course, there's the provision of notification, which we refer to in here, the right of the corporation to inspect and require, improvements, et cetera.
None of which we're gonna change.
None of which are gonna change, and I sort of agree that, I never felt this was, bedrock stuff here.
Yeah, I don't think we have a problem on flip tax collecting it. We know what has to happen. It says you gotta pay the proceeds are 15%. If it's, reconstitution, to the present, and if it's, something recently sold that was recently bought, it's the 1.1%. 1%.
Right now, 1%.
So, what are we screwing with here? Dan?
If it covers our butts a little bit, and a lot, because, look, anybody, flip taxes are challenged, or, they can be challenged, right? And if somebody, it gets creative and says, I have an executed contract, and nowhere in here does it say I must pay this flip tax as a result of, in order to move in, and all my other things are satisfied, I'm gonna sue you if you don't let me move in unless you, give me.
No, but
We say you
it's
don't
the
get
seller
that.
that's paying the flip tax.
You don't get to have your certificate of shares, and you can't move in until you got that, and we control that. You can have any contract.
Let me ask Russell. Russell, up until this moment, there's never been any doubt in my mind that we will never sell an apartment unless we get our participation fee where it's required.
Correct.
They're thinking that we have to put more specific language in our bylaws to make that definitive. Our attorney has never indicated, I don't remember the attorney indicating this to us at any time in any closing. That's what I don't understand.
Here's this, I have a question for the committee, why is this here?
Did Bert say we specifically need this?
A long time ago.
I believe we discussed with Bert the fact that our bylaws don't specifically say that in order for the shares to be transferred, the seller has to comply with all the requirements in the lease all the requirements in the bylaws in the lease for transfer of the shares. It's just a simple, I don't quite understand why this is controversial.
No, I just wanna, it was raised by Hyla, it wasn't raised by me. I'm trying to just make sure we can move forward. Blame Hyla.
Yeah, blame me. I think he recommended that it be in there.
Yeah?
In our
He did recommend it? Okay. So, he'll, yeah, Mike.
Point of clarification, the flip tax is paid, is either 50, in the current bylaws, is either 15% or 1%, 50% of the profit or 1% of the gross, whichever is greater.
Right.
It's not if it hasn't been sold since pre-constitution
Right.
or the other, it's whichever is greater.
Okay, so we'll leave it, okay? We're gonna put that in, it goes before the shareholders. We have to be more definitive in how we collect the flip tax. Advice of counsel. It should say here, by advice of counsel, but why does it say, see section 60 of current bylaws, if they really aren't specific? We don't need to put that in.
No, Hyla added that.
Okay, so let's take that sentence out. That sentence is now out, and we will say, if I can, by advice of counsel must be specific. Is that okay?
Yeah, we add something.
Yes, Bradley.
I think it is okay. I think it would be wise to, in putting this forth to the community, to differentiate between just housekeeping things. There are some things that aren't really fundamental or substantial changes really, but the bylaws have some holes in it. And one of our tasks are to, to tighten up those things where we can. And then there are some other things that are fundamental. And I think if you just say that, it will
relax.
Well, that's why we're adding the words by advice of counsel.
I
That's
think
a- that's
those
good.
words don't relax people.
Yeah, that makes it, I think what Brad said was a lot.
So how do you wanna say it? Because
It's housekeeping, it's just cleaning up
Doesn't have to be
things.
any regulation, you know, like.
Less than.
you wanna remove the words, alright, let's be
Less
clear.
than.
I'm agreeable to almost anything at 11 o'clock at night. Shall we remove the words by advice of counsel, is that the will?
That's
Well, Robert, please, you're a spectator, not a participant. Let me ask this question, shall I remove by advice of counsel? Okay, it's gone. Okay, now, we're down to number 8. And then we're voting, because everything else doesn't matter.
Wait, so what are we doing, 7?
We're crossing out C also, section 60 of current bylaws, gone.
Which is now.
By advice of counsel, my stupid sentence, gone.
I never put.
Okay, thank you. Now we're up to number 8. Let's go, we're almost ready for the vote. What about number 8? I don't know if it's an issue, I'm asking you. They're saying that we shouldn't have the right to buy an apartment.
No. May I explain, this is the rule now.
Let's write down.
We're gonna have to-
We are modifying the enforcement of it
Okay,
by saying that in the bylaws as they presently exist, if the second apartment hasn't been sold in a year, the corporation has the right to buy that apartment at 1/2 the maximum resale price.
Right.
Well, this is one of those implication things, if maximum resale price is gone, then we have to do something else.
well, it could be appraised value too.
Okay, it
Well,
could be,
that's-
but that
that's
seemed like a pain in the
also
neck.
not
So,
very-
what we came up with was a method whereby the flip tax that would be applied to the sale when the apartment finally does sell would increase on a monthly basis after 1 year.
The flip tax?
The flip tax, in other words, if the flip tax were 15% of profit or 2% of gross, then the flip tax would increase by some increment every month.
Is that what it says?
No, no.
It says administrative fee, Mike.
Yeah,
Yeah,
we
right.
initially,
You're right.
excuse me, I'm sorry, we initially
Right.
discussed it as increasing the flip tax on a monthly basis, but, we were advised that it would be better to have a fee, a monthly fee attached to the maintenance.
All right, so
You're exactly right.
we're gonna be asked,
I was misspeaking.
what is a monthly administrative fee? What are we talking about? Dollars or percentage?
Dollars.
It would be
Okay.
dollars put on the maintenance, but that's something that.
Not on the maintenance.
Yes.
Would it be on the maintenance?
We wanted to address as additional rent.
Okay, so in other words, you own apartment 2, you're living in apartment 2, you still own apartment 1, you haven't sold apartment 1. You're paying maintenance on apartment 1, because you're not allowed to sublet
And you have
to
1
stay
year.
there. You have 1 year to sell it.
to do that.
You fail to sell it, your maintenance goes up a certain dollar figure every month that you retain that apartment.
But it's not your maintenance that goes up because there would be legal issues there, so it is an administrative fee.
Yeah, but that would be, as rent,
Additional rent.
Electricity.
additional rent, it's not, it would be additional rent, that's the right word.
No,
Yeah.
it would be an additional fee based on the maintenance.
No, I think you call it additional rent because it has a better meaning
Yeah.
than additional rent is the right words.
Not very.
I'm convinced. We've discussed this before at previous boards. I don't
So
agree.
even if the shareholder's making every effort to sell, you're gonna put this fee on.
We have been selling apartments like crazy. There is no problem selling it within a year, John. Really, there
So
isn't.
you don't need this.
No, we do, because we have 3 outstanding apartments that have been held onto for over 2 years now. And we can never allow this to happen again. We have to get these apartments sold. This is very bad, because we have illegal sublets in those 3 apartments.
But they're not making an effort to sell.
Of course not, because they want a mystical price that doesn't exist. That question, anybody?
Well, the question is what percent?
That's it. What are we gonna say to shareholders? What are we thinking as administrative fee?
$50 a month.
$50 for someone that's breaking our rules?
That's the cost of doing business.
$500 a month, every compounded goes up. 500, 1,000, 1,500, 2,000, it goes up in increments of $500 starting on the first month.
I'd be
That's how you
afraid-
get it.
I would be afraid that if you made it that onerous, a shareholder could break it in court.
I don't think so. Okay. Russell?
It's a little poison pill.
Yeah, I mean, you never know, but.
Administrative fees, he dealt with this kind of stuff. I think.
I don't think we have to make a decision on what it is or what the formula is tonight, but.
No, but you're gonna be asked, you're gonna be asked.
I think we need to know what it is
We
when
have
it's
to have an
presented to the
idea of
shareholder.
something before September. for
Yeah,
sure.
why don't we just, for tonight, say a significant
How about
fee, and
250?
think about it before.
Or it could be something, you know, you could leave the board to set that. You know, I mean, we could put it in there that it's gonna be something that's, you know.
Administrative fee to be set by the board. You can use that language. That's not, what is that, what do you think?
Then it's like subways.
Administrative fee to be set by the board? Sure. Administrative fee as additional rent to be determined by the board. Is that okay?
Gets us off.
Yvonne?
I'm thinking about it.
Well, there might be times when it is hard to sell, like, you know, now we might be using our pocket like 5 to 10.
It's never been hard to sell unless you were trying to imagine a price that no one would buy it for.
So is this something every year the board comes in and makes,
That's why maybe we should have a set the fee.
like,
because
or
the board
every
can change
board
it.
meeting, it's like,
Okay.
well, what do you
So-
recommend lobbying?
Starting at
But let's get the words,
Starting at 300, or starting at.
$50 a month and it doubles every month.
Or starting at $300 a month, or 500, starting
Why
at.
Dollars-
percent?
dollars are
Maybe that'll be
probably-
different
I
for
don't
three
think-
bedroom.
The only dollars are from, you know, you got inflation, you don't know what.
could we put the words in?
Bylaws in 20.
Larry, can I just talk about?
Yes, sure.
I think we have much back on this, I think Dan's suggestion was very good. We have already, the board has already adopted rules in setting administrative fees and fines. And there's no reason we can't do it with this one, rather than, you know, at 11:05, everybody shouting out a number.
I resemble that.
You don't like that?
Let's put it in a hat and cross.
Let's defer it to some time when we're a little less groggy. I think the important thing is that, this is not necessarily for this memo, but we want, the bylaws of the lease to give us the authority to set fee or fine, which, as Milo
No
said,
fines,
can be
administrative
collected.
fee.
Can be collected as administrative, can be collected as additional
Additional
rent.
rent.
The problem that we have with fines, and let me segue to this additional point, the problem we have with fines in this realm is that the lease doesn't authorize the levying of fines.
So that's why you have administrative fee.
So, well, but we're making some changes now. So we might wanna consider an amendment which gives the board the authority to collect fines
Poison pill.
for violation of housing rules as additional rent.
We're able to do everything with administrative fees, and why not just play that game where it's, we think of it as a fine, but it's really, we call it administrative fee, what's wrong with that?
Why would we wanna, first of all, it doesn't.
Put it in the document.
No,
when
you know
we
what?
vote on these.
It's good, that is a poison pill. I think what you gotta do is just put simple language here, 8. This is what it says. We wanna change it, that instead of buying the apartment, the board will impose an administrative fee in lieu administrative
Fee to be collected as
additional rent. Administrative fee to be collected as additional rent, period. Let it go with that. Can we just change that language and then we got number 8 done?
I have one other point, we did.
Right of us just purchasing for half the price is much larger of a threat than saying how much are fee.
But you have to appraise it. You're gonna have to pay for appraisal. This is when we had, maximum resale price, we do the price. Now we won't know the price.
There is no more maximum resale price.
That's right.
Excuse me, I have a comment.
Okay, sorry, I apologize.
Sorry, I think I'm seeing it now, I've lost it, I'm tired.
You're not allowed to be tired.
Oh, the additional rent should appear on the maintenance charges for the apartment that they want to keep.
could think about what you're saying.
The one that's in violation would be the one they're trying
Yeah,
to sell.
we're telling them they gotta
That's the
sell
one that
that.
doesn't attach the fee to.
You can't attach the fee to the one they're not trying to sell, that is absolutely wrong.
No, they're breaking, they are residents and they are shareholders and they'd be breaking a rule. So.
But
you-
only on the apartment they're not living in, not on the apartment they are living
No,
in.
they are a person, they are a person, and they are breaking the rules, so you could put a fine on them and put it on the apartment that they want to keep.
Definitely discuss this.
And you could, eventually, if they don't pay it, like, they could bring up the eviction order, you could evict them if they don't
Oh,
pay
yeah,
it.
that was what in our thinking, at least you have some money.
That's
Some teeth.
Excellent.
So, okay, so make the words, we wanna change it to an administrative fee which will be applied as additional rent on the apartment that the shareholder is currently occupying. Simple?
Right, and if they should move to the other one, that's still the.
Whatever one they're living in is the one we're gonna screw. All right? Do we have number 8 done? Everyone have it? Okay, Yvonne?
So I just want to get the sense, the sense is, the board, this is a floating decision, we're just making what that fee is, which is a
Well, this
floating
document
decision.
sure got short.
We can revisit it as often as we wish.
Yeah, just like any other administrative. Board meetings, all these that we have. Revisit those.
Okay. Yvonne, you have a motion for us, please?
I'll make one up, yeah.
Please.
We've moved that the Board of Directors accepts the recommended changes of the bylaws advisory committee and sets up.
Items
a-
1 through 8.
Items, all right, okay. Items,
Minus
right,
Well, no, 4 is still there in terms of 4C.
right, so we'll just put items 1 through 8 and sets up, a series of meetings for shareholders in order to present and discuss said proposals, beginning in mid-September.
Okay, is there a second?
How about with the board to vote by December?
Oh, yes. With-
Oh, and
A lot of
accepts
work.
Yeah, accepts these proposals after a lot of work, especially by bylaws advisory committee.
With an aim,
No,
with an aim toward
Well,
having
accepts-
a special annual meeting of shareholders in early December. How about getting that in
Yeah,
there?
with the aim of
Yeah.
Holding a special
No, shareholders.
a special
shareholders meeting. Yeah, that's what I said.
Early.
You said annual.
Oh, now I know I gotta get out of here. Okay. Okay.
Wait one moment, let me finish this sentence, because I don't remember. A special shareholders meeting in December?
In December.
Okay, but Highland has an amendment and she's correct. Where do I put that? Tell me that again. That the board of directors accepts the recommended changes of the bylaws committee, items 1 through 8, and then.
As reviewed and amended by the board.
As reviewed and amended by the board
Tonight. Or at this.
or at this
On
meeting.
July.
On July, put the date in, on July. I wanna tell you, I don't want anybody to say that this board doesn't earn its money.
2013. Okay, that the board of directors accepts the recommended changes of the bylaws advisory committee items 1 through 8 as reviewed and amended by the board on July 23rd, 2013, and sets up a series of 3.
A series of meetings is fine.
For shareholders in order to present and discuss said proposals beginning in mid-September with the aim of holding a special shareholders meeting in December 2013.
Okay?
Yada, yada.
Is there a second? Is there a second? Second by Jerry. We have discussed this in every possible way you can discuss a document that nobody knew. We are now ready to vote because we are much more intelligent. Ready? We're going to vote. All in favor? It is unanimous. Okay, I want to inform the board. The The September MGCA meeting, the chair is here. September 12th? Will you be ready to present on September 12th?
I thought maybe,
October, you wanna do October?
Maybe October.
Okay, but I am
September
planning,
12th is early.
then there'll be 2 town hall meetings, one on 9/22 Sunday, it'll be an afternoon meeting, and a town hall meeting Wednesday night, 9/25. And then
Wait, could you give me those dates?
9/22 Sunday, and 9/25 Wednesday evening. The next meeting, town hall meetings, dealing with the bylaws, and then there'll be the October meeting at
I think it's
NGCA.
October 3rd or something, I think it's the October.
There was an October early meeting.
I think it's the 3rd. Thank you.
I'm gonna tell you right now, I have it because it's in my calendar, for some reason I have to be there. October 3rd.
No, you have to be there in September.
I have to be there in October too, 'cause that's the money. October 3rd,
What's on October 3rd?
MGCA.
Oh, okay.
So we'll be there town hall meetings, 9/22 Sunday afternoon, time to be determined. Wednesday, 9/25 evening meeting. I know the chair of the committee will be there. I would like the committee members to be there. I would like every board member to be there. This is a unanimous vote. We're moving forward. This is an amazing moment. Okay? Thank you. October,
Special thanks to the
9/22,
yes, I want to
committee members who
extend,
sat at this table.
I want to extend to the bylaw committee members a grateful thank you for the work you have done, starting in December and getting to this point. You have no idea how this is going to affect the community if it passes successfully. This is a major, major moment in this community. And I appreciate it, and I think every board member does. Okay. It's gonna go to flash report, and I'm gonna set it up, and we're gonna do it. All right, so everybody has that? We're now up to, God knows what the hell I'm up to. Oh, thank God. Thank you, John. This should be fast, I think. Because there's nothing on the agenda in closed session except management report.
Have a good night.
Very good work there, Bradley.
This is the first time I've ever seen that.